Professor in the Honors College here at UNLV.
And my name is Jeffrey Connor. I'm Chief Deputy Solicitor General at the Nevada Attorney General's Office. Really happy to be here.
My name is Ariana. I'm the casework director for the Office of Senator Reports and Aspects.
Want to introduce yourselves?
Hi, I'm Dalton Bellows.
I'm Roxy Paul.
I'm Kelowna Wallace, and this is Unit 1 of Reed High School.
Sure. All right. Unit 1, what are the philosophical and historical foundations of the American political system? Question B. How did colonists' practical experiences of self-governance in the British colonies in North America shape their views on political authority and representation? How did the colonists' observations about the British government contribute to their ideas about rights and governance? Please provide examples of specific grievances. And how do those historical grievances resonate with or differ from contemporary concerns about government overreach or individual rights in today's political climate? Please begin.
Colonists' experiences with self-governance contributed to their beliefs in popular sovereignty and legislative supremacy. James Madison said, "In Europe, charters of liberty have been granted by power. America has set the example of charters of power granted by liberty." The colonists experienced arbitrary rule of a monarch. All state constitution featured legislative supremacy, and the U.S. Constitution was ordained and established by the people, and Congress was most powerful.
The founders experienced only virtual representation by the House of the Commons, and people were taken overseas to be tried by crown-controlled judges. Benjamin Franklin wrote, "There's a defect in the Constitution of the British Empire in respect of their protection of liberties in the colonies." This led founders to embrace direct representation rather than virtual. First, with the idea that representatives must live in the area they represent. Then with a local jury trial being guaranteed in the Article 3 and the 6th Amendment. And finally, Article 3 created an independent judiciary.
The Stamp Act aimed to silence dissent among colonists, and many believed that Parliament had no right to tax them through the Sugar Act, because again, colonists only had virtual representation through the House of Commons. Americans' ideals were different from the British with regard to a greater sense of individual and collective self-determination. Thomas Jefferson said, "Free people claim their rights as derived from the law of nature, not as a gift from their chief magistrate."
The Declaration of Independence shows how American colonists suffered a long train of abuses at the hands of King George and Parliament, who had dissolved colonial legislatures, obstructed justice, and made judges dependent on the King's will. These actions led the new states to provide for legislative supremacy and ultimately an independent judiciary in Article 3.
The British quartered troops without consent, used general warrants to invade property and privacy, and denied due process, including a trial by jury of peers. Eventually, these rights would be protected from the 3rd to 6th Amendments.
These historical grievances generally differ from contemporary concerns. Historical grievances often involved dissolved legislatures, whereas today, dysfunction arises from the filibuster and partisan gerrymandering. Despite ideological divides, federal courts have earned trust through independence, frequently checking the executive and legislative branch to uphold the Constitution.
The court ruled against legislative state and federal flag protection acts in Texas v. Johnson and U.S. v. Eichmann in order to protect the First Amendment. The court ruled against executive authority in Mapp v. Ohio, Miranda v. Arizona, and Gideon v. Wainwright, protecting the 4th, 5th, and 6th Amendments. They ruled against presidents being above the law in U.S. v. Nixon and Clinton v. Jones.
Jury trials are not seen as crucial today, as 95 through 98% of cases use plea bargains, which we have not experienced the threat of troops being quartered in our homes, and due process has been greatly enhanced, especially through the court using the 14th Amendment's due process clause to incorporate substantive and procedural rights.
However, grievances that continue to resonate from colonial times to today are 4th Amendment concerns. In Katz v. U.S., evidence was thrown out due to a warrantless listening device in a public phone. In Kylo v. U.S., the court decided that the use of a thermal imager to find high-intensity lights used for marijuana growth was an unconstitutional search. And in U.S. v. Jones, the court struck down the FBI's use of warrantless GPS tracking. To connect it back to colonial times, in a 1755 letter, Benjamin Franklin declared, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety."
Thank you.
Good.
Okay, all right. Okay, guys. So you guys bring up some really good points here. And to kind of synthesize them together a little bit, here's my question for you. Because as we know, really one of the foundational pieces in all of this is having the right to vote. And so here's my question for you guys, okay? So thinking about time during the colonial period, in what ways did differences in property requirements for voting across the colony shape colonial political culture and ideas about representation? And then how might you guys link that to contemporary society?
It shaped their ideas with how people should vote because these property owning males wanted to make sure that the people making decisions were enlightened. And this is why in Article 2, Section 1, Clause 3, we have the electors that actually elect the president, not the people. And so we can see that this is even continued today where the people don't directly elect the president. It's through a body of electors because they wanted more enlightened people deciding.
The Mayflower Compact, with the Mayflower Compact, it was 41 white rich men who created this new society in Plymouth and were able to vote. And we have fixed issues like this today through the 15th Amendment that allowed other races to vote, in the 19th with women's suffrage, and the 26th with allowing 18-year-olds to vote. So we have greatly expanded voting rights since colonial times.
How can ideas of religious freedom from colonies like in Maryland and Pennsylvania help shape current discussions about government and individual rights in the U.S. today?
Well, because of when the topic becomes a religion, we have freedom of religion in America protected under the First Amendment. And because the colonies and we were getting away from the British because they were obstructing all in freedom of religion. And this is why the Quaker William Penn had his own colony that was appointed by the king.
Yeah, and he had the law of conscience, which greatly affected the First Amendment, where other colonies didn't always have this right of tolerance, but it greatly influenced the First Amendment and how we think of it today. We still ensure that there is broad protections for religion, and this can be seen in many court cases that have upheld the idea that freedom of religion is important. And
in the Virginia Declaration of Rights, written by George Mason, he details the freedom of religion, and Thomas Jefferson took that when he wrote the Bill of Rights into the First Amendment. And we can see this protection in the case West Virginia v. Barnett, which said that the people didn't have to stand for the pledge, and it was people of a different faith who didn't want to pledge under God part of the Pledge of Allegiance.
this has even influenced individual liberties, with more states saying that you can't compel someone to speak, and in Texas v. Johnson, saying that you can burn the flag in protest. So it really shows that we have a broad protection for freedom of expression.
Kind of a two-part question. In your opening, you mentioned United States versus Nixon and Clinton versus Jones. Of course, we just last Supreme Court term had United States versus Trump was decided on the issue of executive immunity or presidential immunity. Do you think there's tension between those cases and what the court said in United States versus Trump?
Well, Nixon v. U.S., it was referring to things that, it was basically saying that no, President Nixon is not above the law, while Trump v. U.S. is saying if he's acting within his official acts, then he won't be held liable. And this is not really in conflict because it doesn't go back to, they can still do illegal things, but the founders wanted to make sure that the president couldn't be too swayed by the moving of politics.
To disagree with my colleague, in Trump v. U.S., it said that presidents acting under their official duty are immune from litigation, and in Nixon v. U.S., Nixon claimed that he didn't have to hand over the tapes because it was presidential confidentiality. So these two do clash a little bit, since in Trump v. U.S., Nixon would not have been tried because of presidential confidentiality and was acting under his official duties. And even though Trump v. U.S. did give Trump a lot of, you could say, power, in the recent Supreme Court case, Trump v. New York, his own appointee, Amy Coney Barrett, ruled against him, saying that he did have to face the charges of these 34 convictions, even though he didn't actually have to go to jail for anything.
So, and then to follow up on that, even though the court did reach the conclusion that the president is immune from criminal prosecution for his official acts, what other provisions of this Constitution could be relied on to challenge the president if the people think he's overstepped his authority?
In Article 2, Section 4, you have the impeachment of all high officers, including the president and vice president. And we've seen this with President Clinton, who was impeached but not actually removed from office by the Senate. And so we still have these processes in place. And although we still haven't had a president impeached, that threat of impeachment is very high, especially as the Senate in Federal 62 was said to be this enlightened branch that wasn't too swayed by everyday politics. So we see that they definitely can decide differently from how the president would want.
Another way that people can check the president is by suing his actions. For example, after Executive Order 14156 tried to redefine the birthright citizenship clause of the 14th Amendment, the ACLU and 22 other states immediately joined in a lawsuit, and now it was recently blocked by a Washington judge. And in Biden's administration, in the court case Tennessee v. U.S., Justice Reeves, who is a federal Kentucky judge, blocked the U.S. Department's revision to Title IX of the Civil Rights Act to change the definition of sex to include gender, and this forced people to use the proper pronouns that other people wanted them. And this went against West Virginia v. Barnett, which said that you can choose not to speak. And the judge also said that in Chostic v. Clayton County, which ruled that you can't discriminate based on sex and gender in workplaces, that it didn't apply to schools since they are a special circumstance.
And that's Bostic v. Clayton County.
Thank you.
So I think just to kind of circle back and touch on a little bit of the nuance here of the question that my colleague here posed. It's interesting, if you look at what President Nixon said, if the president can do it, it's legal. He would have been laughed out of the room. President Trump says the same thing. Nobody's laughing and saying, well, that's possible, right? So I think it's an interesting little bit of nuance there in looking at context of what is happening. And so it can bring some concern. Saying, okay, now nobody's laughing. Trump can do what he wants and without any repercussions, right? So I think it's important to keep a little bit of that nuance in mind and looking at the different historic time periods, but looking at their similarities as well, right? And then a second point I want to circle around back to here was when I asked you guys about property and whatnot. I think it's also important to keep in mind, how important it was to own land, but how was that land originally acquired? Involving the displacement of indigenous people, negotiation of treaties. In some cases, some of the treaties were falsified, right? So I think it's kind of important to keep those things in mind, but that's just kind of my final point here.
Yeah, and a colonial experience, what you're speaking of with trying to gain land was the 7 Years' War, which caused all of these acts to be put on the colonists, like the Stamp Act and the Sugar Act, which made them so frustrated at the British government because now they're being taxed without representation. And so with their need for land under the 7 Years' War and they wanting to go and get that, it almost caused this independent fervor for then cause the Revolutionary War. So I'm very glad that you brought that up.
So, in your opening statement, you also mentioned the right to trial by jury. How does the right to trial by jury limit executive power? But of course, you've relied on the courts can do it, but the jury is a wing of the court. But what role does the jury play in limiting executive power?
Well, this goes back all the way to the Magna Carta, where they were trying to limit the king's influence. And a colonial complaint was grievance 18 of the Declaration of Independence that said that they're not being tried by a jury of their peers. And so the jury's job is to act as a people that are of the same beliefs and common values that can decide their fate, not just one person and judges appointed by the king, like in Britain, where they were deciding on the king's will.
We also see this because the judiciary court is supposed to be completely unbiased, and they're not supposed to go based off of what they think. They're supposed to go off of the Constitution and how they interpret the law. As my colleague said, that Justice Amy Coney Barrett ruled against President Trump in Trump v. New York. And we see that because because we have these people in the court, we rely on them to make sure they're interpreting the law as the Constitution is growing. It's a living Constitution, and how they're going to implement what's going to happen. As we saw in Gideon v. Wainwright, it established a right to an attorney no matter the case, and then we saw this in Miranda v. Arizona, and how the courts decided that we have to have Miranda rights being told to you. So this is how we have to make sure our judiciary court is completely unbiased.
And then it limits the executive authority, because in Map v. Ohio, it established rules like the exclusionary rule, and in Gideon v. Wainwright that they have a defendant. So it's making sure that the executive isn't going too far in punishing these people, and making sure that they have protections, because just like under Miranda v. Arizona, you should be read your rights before you're arrested, so you're not just under the impression that you have to self-incriminate.
And the court case Weeks v. U.S. is what created the exclusionary rule, which Akil Reed-Amar, a proponent legal scholar, is very against, because of all the exceptions that can come with that.
All right.
You guys did really great in the delivery. I think you guys answered all the questions and really clearly, and gave really great examples, especially in how today's climate and politics is. So thank you so much.
Of course, thank you.
I'm impressed, guys. Great job. Man, you guys brought a lot of really good stuff to the table here in responding to our questions and everything. Yeah, very good. My only kind of like little minor suggestion, as you guys are, telling us about all these different things that are happening, bring in a little bit of nuanced context, and you'll be right on. You'll be absolutely perfect. But great job. You guys did a really good job.
Thank you.
Thank you for that.
Yeah, excellent job. I mean, the amount of evidence you guys cited to and relied on, just across the board, lots of great historical evidence, but also contemporaneous things, and mixed in, the way things have kind of developed over time. Yeah, I think that's some great constructive criticism there, is to just don't get so focused on just throwing out as much evidence as you possibly can, and make sure you tie it in to what you're talking about. But that's a really high level thing. Like that's, you guys did an excellent job. So if you guys move on, which I think could be a possibility here, that's just something to work on. But excellent work. And really good job.